Good afternoon. I'm Bethany Saxon, the Director of Communications at the Center for Public Health Law Research at Temple University's Beasley School of Law. It's my pleasure to welcome you and thank you for joining us for our first Legal Epi at Lunch webinar for 2026. Today, we'll be hearing from presenters whose research focuses on stigma, and we'll learn more about their work applying scientific legal mapping methods to better understand stigma-promoting and stigma-inhibiting laws related to addiction and to abortion. A few housekeeping notes before we begin. We will be recording this webinar. We will distribute the recording and slides to all registrants of the webinar, and we'll post the recording and slides on our website, phlr.temple.edu, and on YouTube. We've reserved time at the end of the webinar for your questions. You are welcome to use the Q&A box in Zoom throughout the duration of the presentations, but we will address those questions or comments at the end of the presentations. Our webinar today features two presenters. First, we'll hear from Daniel Goldberg, Professor and Director for the Center for Bioethics and Humanities, the Farley Health Policy Center, and the CU Public Health Ethics and Law Program at the University of Colorado Anschutz Medical Campus. Next, we'll hear from Kelly DeBee, a legal epidemiologist, researcher, and lecturer at Colorado State University, and affiliate instructor at the Colorado School of Public Health. Dr. DeBee is also a CPHLR Research Fellow. Now, I'd like to welcome our moderator, the Director of the Center for Public Health Law Research, Scott Burris, who will offer a short introduction.
Hello, welcome. I'm really excited to be hosting this webinar. I'm really grateful for everybody who's taking part and has helped arrange it, because stigma is a topic that I have been very concerned about for many, many years. Next slide, please, Bethany. My sense of stigma goes back to Irving Goffman's, I think, 1963 book of that title, which was a true scientific landmark in social science, a piece that really has such power that nobody dared talk about stigma for the next 20 or 30 years. In Goffman's understanding, stigma was not a characteristic. So the disability, the using the drugs, the getting an abortion, that's not the stigma. The stigma is the shared belief between the person who has the trait and what Goffman referred to as the normal, or the, and definitely in quotation marks there, the other, in which it was agreed between them and within that social context that trait was discrediting. And it was, for Goffman, he called it a pivotal fact that the stigmatized individual actually tends to hold the same beliefs about that identity that then the normals do. So in other words, the powerful thing about stigma, the thing that makes it so insidious as a form of social control, as we lawyers might think about it, is that most of the work of social control, most of the suppression of the identity, most of the discrediting of the idea is actually done within the person who has the trait, right? It's a self-enforced form of social isolation and misery, which has always made it to me a particularly odious form of social control. Next slide, please. After about 20, 25 years, there started to be more work on stigma. And a view that became particularly salient in the era of AIDS and is widely used was the Lincoln-Phelan model, which I think of as a social view of stigma, and more particularly as a view of how stigma actually gets created. So that's what we call here the social level view on this slide. And they depicted a social psychological process. The difference is noted, and of course, lots of differences are noted. Who's bald, who has hair, who's a lawyer, who's not a lawyer. But in a certain instance, that becomes, some of those characteristics become linked to negative stereotypes. Well, I guess you could say that about lawyers, and maybe you could even say it about bald people. But then there's another step, the idea of us versus them distinctions. That identity becomes kind of a group marker. You belong to the group, you don't belong to the group. And ultimately that leads to your position in that group, leads to status loss. You become less of a person, you become subject to discrimination. But for them, the dimension of power on the left was crucial to all this, because lawyers are noted as different. They are linked to negative stereotypes. There are us-them distinctions about lawyers, but lawyers have power, and they really don't suffer status loss. They usually suffer status increase, and they're not really suffering discrimination, right? So power, the ability to take the fact that there's a group of people in society who can take those us-them distinctions and exercise power to cause harm to others is crucial to making something stigma. But of course, even then, I think this model is a little bit overbroad, because almost any disputed thing that might become thought of as a characteristic and linked to stereotypes can be thought of as could be subject to this process, at least in some places. So that at least in some circles, we lawyers might actually suffer status loss and discrimination. Pretty isolated, rare circles, but it could happen. And it wouldn't involve stigma because of going back to that key idea of Goffman's, that we lawyers do not share the sense that our identity is spoiled. We may not be treated well, we may even suffer discrimination, but we do not suffer self-imposed harm because we ourselves think we're great. And it's the rest of the idiots that have the problem. On the other hand, if you look at the other side of this picture, this was a model developed that I've sort of extracted from the work of a fellow named Graham Scambler, who studied epilepsy, which was for centuries a stigmatized condition, and still in modern times may carry some stigma. But what was interesting about his view, he really followed upon Goffman, and he looked at two different strategies that he found his subjects undertaking when they became aware that they carried this potentially stigmatizing trait. One was to accept the idea that they were now less, that in fact it was bad to have epilepsy, that epileptics were people who could not lead normal lives, that they could not have families, they could not have careers, and whose best chance was to try and conceal as much as possible the stigma. And of course, that's the classic both strategy for managing stigma, as Goffman described it, but also really the way that people hurt themselves most. They hide. They cut themselves off from opportunity, from relationships, from social life in order to engage in concealment. Now, they still sometimes suffer the harm, status loss and discrimination that Lincoln Phelan described. Sometimes they don't. They successfully avoid it, but they still carry what he identified as hidden distress, compared in his study to people who decided they didn't believe that. They were going to resist the stigma. They were going to be open. They were going to educate. They were going to use resistance strategies like educating people, like talking about the pride of their coping. However, it might be lots of different ways that groups that have been subject to stigma begin to resist it and fight it. And in his research, some of the times those people did suffer discrimination in spite of their strategy, but he found that they suffered overall less harm. And so, this was interesting to me because it captured the dynamic quality of stigma as a shared relationship. In other words, the strength of stigma is that I share the idea that I am bad, that my trait is discrediting. But if I cease to share that idea, much of the power of stigma to control me disappears, because the control is not coming from outside, it's coming from my acceptance. If you go to the next slide, please. Building the suspense. So, that allowed me to sort of think about a way in which you could tie law to that dynamic process of stigma resistance and attempts to create or impose stigma, right? And it works on it sort of positions our legal work on a spectrum. On the one hand, on the top, you have a condition in which stigma is actually prevalent, highly powerful, which people very broadly held beliefs among both those who have the trait and those who don't have the trait, that the trait is discrediting. And on the other hand, where stigma is actively contested, where in the vision of Scambler's model, the people who share that trait have stopped accepting that they are bad, that their identity is spoiled, and started to resist and fight that. And law plays a different role as you move along that spectrum. So when we have, say, in 1960, the stigma of homosexuality, of course, we had prohibitions in the law that reinforced that idea that homosexuality was bad. There was what people were doing early in the in the resistance era, the civil rights era for gay and lesbian people was beginning to try and change social attitudes. Um, and as social attitudes began to change and as people began to fight the stigma, they faced a lot of discrimination, in which case the role of law emerged as trying to protect people from discrimination and validate their status. But as the process of destigmatization grows, law becomes much more a site of contest over stigma in the classic sense of two different factions of society are trying to use the law to express their views on the behavior or on the trait. So then the fight over marriage becomes a fight over whether our law is going to validate traditional families or it's going to validate the inclusion of gay and lesbian people. As overt discrimination declines, you still have sort of the problem of structural discrimination that reflects the historical negative attitudes of the stigma, and the importance of freeing people from self-discrimination becomes much larger. Can people feel that they can go out? Can they feel that they're safe to be open, to be out of the closet? And in that sense, we often reach a state where law is sort of regulating discrimination, and in the sense that it's saying what is forbidden and what is not. We're seeing that with the world of trans people now. Law is trying to figure out when is it okay to discriminate against trans people, actually saying that that's protection of people from poor medical treatment or something else, versus when we're trying to truly bring an integration of people with the trait into a society. And I think this is by way of introduction for today's two talks, both of which it seems to me are situating themselves along the spectrum of contest over stigma. The stigma of abortion, I would say, as a statement about the nation and leaving aside particular places and corners of the world, there's almost no stigma of abortion left, in the sense that people who get abortions, many people who get abortions do not feel the least bit spoiled or it's completely acceptable determination of one's own life. They're not struggling with stigma. Their people are probably struggling, and that's the point. Where is the law encouraging or promoting a feeling of spoiled identity among people who have abortion, and where is law acknowledging the fact that really there's nothing wrong with that? That's a choice that you can make. We're in a contest area, but I think we're sort of lower on this picture towards contested stigma. Whereas with drug use, substance use disorders, the power of the old stigmas of drug use remain really powerful. Really, the power remains great, and the law continues to reflect not so much a contest as an attempt to begin to change the many legal elements that continue to reinforce the stigma. And Daniel's going to talk about that. So with no further ado, let's look at two examples of how law and mapping law helps us understand where we are in stigma fights and what can be done next. So Dan, you are on.
Okay, great. Just wasn't sure if I was ready to go. Okay, so hi everyone. I'm Daniel Goldberg. Thanks so much for being here. It's really a great pleasure and honor. I'm a huge fan of the Center for Public Health Law Research, so it's just great to be on this webinar. So I'm going to talk a little bit about a study that a team in which I was involved with sort of did in using vertical legal mapping techniques to assess addiction stigma. I know I'll be talking about the study in particular. What I really would love to focus on, and I'll get to this sort of more towards the end of my time on this, is some of the difficulties that are involved with mapping stigma in particular, right? Like it is challenging, and there are some challenges involved, and I'll talk about what some of those challenges might be and what some of the how we handled it as a team, and what I hope that we will be able to do as people who are working on this using techniques of legal epidemiology to sort of think about stigma. So next slide, please. Thanks. So why even talk about law and stigma? I mean, there's obvious connections between stigma and law, thanks Scott, right? So obviously, like most of us who are working in this space who have followed Scott, we followed Scott literally, right? So that was part of my introduction to this about 20 years ago. And it, to be honest with you, kind of blew my mind. It's still blowing my mind a little bit, right? But so one of the ways I think about this is when we think about stigma, and this comes from Lincoln Phelan's conceptual model, so tracking some of that as well. But one of the things that jumps out from Lincoln Phelan's conceptual model, and this is in Scott's work and many other people's work as well, is that stigma is really a structural determinant of health. What do I mean by that, right? So if you look at this model of the revised social determinants of health framework that was created by Ruqaiya Yarbi, who's associated, I know, with the center as well. So thank you, Professor Yarbi, for this, right? Professor Yerby, thank you for this. So if you look at this, if you look all the way to the left of this image, I'm not going to go through the image in detail, but if you look all the way to the left of the image, you see that the root cause that produces the outcomes, which is all the way to the right of the image, right? The root cause is structural discrimination, right? Structural violence. But immediately to the right of that, what comes up is law, right? Which makes sense. Law is a very, very, very powerful determinant of health, right? And this is sort of the axiom for public health law work and public health law research in particular, right? And so thinking about that means that when we think about stigma, as Scott has described it, it would be surprising if it didn't find its way into law, given sort of how high up the causal pathway between exposures and outcomes actually is, right? Like law sits pretty much directly next to forms of structural violence in its ability to shape systems that produce the inequalities in health outcomes that we see. So partly my interest in this is thinking about law as a tool. Law mediates stigma, as Scott has talked about, it channels it. And unfortunately, laws, I think much more frequently, certainly in the US, historically has been much more frequently used to intensify stigma, but that also means that it can be used to actually ameliorate stigma as well, right? So harnessing a sort of powerful mechanism. So structural problems require structural solutions, and law is not the root cause, but it's pretty high up the causal chain. Next slide, please. So in the study, which I'll describe in a little bit, which is a mapping study of addiction stigma in California law, and I'll talk more about this as well, but just this idea of structural problems requiring structural solutions, a huge amount of the anti-stigma work that actually happens are what I call downstream interventions. They are, I have referred to them as methodologically individualistic interventions, in that they depend for the individual to change their attitudes, practices, and beliefs as the unit of change, right? And there is good evidence behind this as an approach. So I'm certainly not saying that we shouldn't do it. But as you would predict with a structural determinant of health, any structural determinant of health, whether it's stigma or anything else, right? We would predict that these sort of downstream individualistic interventions don't move the needle much, right, on these sort of structural upstream determinants of health. And that's exactly what we find, right? So the anti-stigma work that's done on that individual level, it tends to have modest effects, and the effects tend to be transient. We don't know how sticky they are. So this is the stigma impact pyramid. For those of you who are coming from a public health perspective, you may recognize it's a bit of an homage to Frieden's pyramid, of course, as well, right? But that the most powerful sort of, I think the most powerful forms of anti-stigma work are on the base of the pyramid, and as you go up, right, it gets less and less and less effective in terms of its impact. Sort of ironically, it actually gets easier and easier to implement those interventions than, of course, to make massive changes in state or federal anti-discrimination law and redistributive interventions, especially in our current historical moment, right? But nevertheless, this is sort of the theory that guides the project, is harnessing the power, and a lot of my work in general, harnessing the power of law as an anti-stigma and an anti-discrimination device. What would it look like if we did that? And then thinking beyond just sort of changes in federal and state anti-discrimination law, which I'll talk about as well. Not that we shouldn't do those things, we should. But as I generally try to talk about in my work, there are a lot of challenges with what we call macro level anti-stigma legal change, right? Which it tends to have a pretty long time horizon. Like, when are we going to get new federal anti-discrimination laws that we enforce, right? We should work for that, but people need help now, tomorrow, right? And so we have to find some ways of harnessing law to help people tomorrow. And that macro level change might not work tomorrow, right? There's not a great policy window for that. So next slide, please. Okay, to remediate stigma in law, we have to know where it lives, right? Now, some kinds of stigma in law are very, very obvious, right? Like, I know that CPHLR just put out something new on Law Atlas, which I love dearly, on HIV criminalization. So, of course, the obvious place for stigma when we think about health conditions is criminalization. And of course, that is definitely a major part of where stigma lives. But the thing is, stigma is structural. It's insidious, right? And I think Scott even used that word. And so one of the things about the insidiousness of stigma is that it would be surprising if it only lived in criminal law for these kinds of things, whether it's persons with addiction or persons seeking abortion and certain kinds of reproductive health services, or anything else. Like policymakers do not always write in red crayon, these laws and rules are intended to stigmatize folks. Now, I realize in our current historical moment, they're actually doing that a lot more, I think, than they used to, but still, there are we have very good reason to believe there are going to be lots of laws and policies where stigma might live, where it's not transparent, where they're not using that red pencil or that red crayon. And in addition to which, and this is a critically important point, stigma is structural. It can exist in concert with legitimate public health ends, right? Like the world, and we talk about this a little bit in the manuscript, my research team and I, the world's not divided into laws that stigmatize and laws that achieve just public health ends. Like it would be a much better world if that was the one we live in, but it's not. The history of public health in the modern West is littered with examples where legitimate public health ends actually also intensified and perpetuated stigma against marginalized groups. The classic paradigm of this is public health surveillance, right, which is both very important and has legitimate public health ends and can result in all sorts of problems for marginalized and oppressed groups. So trying to figure out where stigma lives in law, where it's not at first glance totally obvious, right? And this is where legal mapping techniques come in. So next slide, please. So there's my allusion to Seinfeld. I know Seinfeld hasn't aged all that well, but there it is, right? Like there are problems that are involved with this, okay? And one of the basic problems is that figuring out how to map stigma, the method of this to code stigma using legal mapping techniques drawn from Legal Epi is actually really, 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 really challenging. So there are a number of different problems. I will only touch on a few of them here, right? Obviously, in legal epidemiology, we're focusing a little bit more on measurement over interpretation. And of course, I've done my work in the history and philosophy of science, so I understand that this is a false dichotomy. Everyone knows that, okay? But the idea is that it's about our emphasis. We're really focusing more on trying to measure where stigma lives in law before we're sort of applying our own interpretations of whether this is good or bad and how this actually works. This is very, very challenging. Stigma is complex. Sometimes it's abstract. It's often opaque and hidden. It's also often transparent. We can find lots of examples of both. But if we don't know all the places where stigma is living sort of underneath the surface without us really paying attention, then we can't really do the anti-stigma remediation work that we're looking for. So what the team and I sort of realized at the outset is you can't code a question like, does this law promote stigma? Right? That's a wildly interpretive question. And it's appropriate for some kinds of legal analysis. So I'm not criticizing them for how we would think about stigma, but really trying to measure ex ante before we even look at the effects of that law, really trying to sort of assess and measure whether the law is likely to promote stigma or inhibit stigma. Coding, does this law promote stigma, is tautological. It's going to differ between coders and evaluators, right? You're going to have different views on that. And so it's not really well formed. You need some different ways of trying to measure and code stigma in law. Next slide, please. So the study that we did, and I'm not going to describe the study in huge detail because it would take too much time, and anyone can read that study if they want, okay? And if you don't have access to it, please email me because I would love nothing more than to share it with anyone who's interested. But what we really looked at is we focused on vertical legal mapping. Vertical, another word for vertical is just intrastate, right? But a lot of legal mapping studies in legal epidemiology are horizontal. They're interstate when they're looking at the US. They're comparing the laws of California to Colorado to Pennsylvania, et cetera, et cetera, et cetera. And interstate legal mapping is very, very powerful. It's, of course, how we get close to these sort of giant 50-state data sets where we can really sort of compare across states and see what different states are doing. So really powerful, answers a lot of legal questions. But it's all about the research question that you're interested in, right? Like by definition, interstate or horizontal legal mapping, there are questions it can't answer about vertical legal mapping. So the classic example, and it's not really so much for this study that I'm describing, but I'm working on another study right now where we're really investigating questions of state level preemption with local and county governance, right? And obviously you can't answer those kinds of questions through an interstate model. So there is a need, and so this is not an either or, this is a both and kind of approach. We need both vertical and horizontal mapping, both interstate and intrastate. But this study was an intrastate where we're really looking at California, which I think, as most people know, is what, the third or fourth largest economy on the planet, basically, if it was its own place. So California is highly complex. There's a lot to say about California just within its own state. So we looked at states, counties, and municipalities, and we sort of performed our analysis on a sample of the county and municipalities in particular. Next slide, please. So this just gives you an example, and if you're interested in figuring out our process and what we did, it's all laid out in the paper itself, which was out at the end of 2025. It's in the International Journal of Drug Policy is where this is, and again, I'm happy to share it if anybody wants to see it. We published a policy brief that was in Health Affairs a couple of years previously, but the outcomes manuscript is just published. So this is just an example. I'm not going to talk in huge detail about this, but first we had to develop a concept model. One of the methodological challenges with mapping stigma in law, in particular, is construct validity. Like, how do you know whether a law stigmatizes, whether it promotes stigma, whether it inhibits stigma, or whether it really doesn't have anything to do with stigma at all, right? You need the construct and the concept of stigma, and that's really, really challenging. That's one of the hardest things, I think, to do. So we developed a concept model that, of course, is based on both Scott's work as well as Lincoln Phelan's work. And this is just an example. There are other components of this in our concept model, which we described in the paper, but we focused on this in versus out group separation. And then we developed some preliminary constructs consistent with methods and legal epi, where we tried to map these preliminary constructs onto the components of the stigma concept model, basically. We identify things like geographic restrictions for persons who use drugs and persons with addiction. We identify possibilities like benefit restrictions, right? Do these laws actually restrict social services and benefits for persons who use drugs and persons who live with addiction, right? From this, we went on to develop these coding questions, and these are just an example of the coding questions. Does this law contain zoning restrictions? Does this law contain housing restrictions? Does this law restrict benefits to persons who use substances? And this is how we went about trying to code it. Next slide, please. So just reporting out some of the key findings, and again, you can read the manuscript in more detail if you want to, and or read our policy brief, but we found out that every jurisdiction that we surveyed had some laws that promoted stigma against persons who use drugs according to our concept model and how we thought about it. Just to give you some examples, 80% of the jurisdictions exercise geographic restrictions for substance use. So they said that persons who are in active recovery, for example, can't live here. Recovery facilities, assisted living facilities, right? Those kinds of things. They can't be in these neighborhoods. They can't be here. They can't be there. They can't be within 1,000 feet of a school, et cetera, et cetera, et cetera, right? 43% of the jurisdictions we surveyed deployed nuisance law. And I'm just picking this up because I think that this is really one of the interesting findings from our study that can be used to develop work. In particular, there's not a lot of work in legal epi yet that I think has really looked at nuisance law as a way of sort of accelerating or intensifying stigma against marginalized groups. But there's a big history here, right? There's a long history of nuisance law being used to enforce structural violence, and in particular, anti-Black racism. Nuisance law was also used against Jewish communities throughout the South in particular. I lived in Houston for a long time. Most of the private deed restrictions in Houston actually prohibited, if it's an old enough property, they actually prohibited conveyance to Jews, right? So but one of the things you'll find as these pictures here are showing you, this is from the Federal Housing Administration's underwriting manual in 1938. It's well known the history of redlining is consistent with the FHA. This is just showing you here pages from this 1938 manual that actually talk about the racial problems with quote unquote racial occupancy. And you can see it's directly in the section that discusses nuisance, right? That's not an accident in the FHA that they're putting the use of nuisance and nuisance law in conversation with just invidious anti-Black racism. A few pages later, which is the bottom sort of citation there, you can see they actually have nuisances pretty much in the same section as the stables and pig pens. And the very next line juxtaposed with that is prohibition of the occupancy of properties except by the race for which they are intended, right? So just a lot of sort of connection between historically the use of nuisance law and the intensification of stigma and discrimination against marginalized groups, right? 64% of jurisdictions promoted stigma in findings provisions. I'm not going to spend a huge amount of time talking about that. Findings provisions, for those of you who have less of a legal background, are like preambles to legislation. They sort of say, hey, the legislature said, hey, this is why we want to regulate in this space. They are not operative provisions. They don't actually do anything in terms of the law. They just explain why the legislature wants to govern in this space. They have tended to be ignored because they are not operative provisions. And one of the findings of our studies is that stigma tends to be pretty active in finding provisions. There's a lot of stigmatizing language in these findings laws. And given that courts in particular do use findings provisions to discern legislative intent and in their statutory interpretation, we think that there's a mandate or at least a justification for taking a closer look at what findings are doing and the way that they are promoting stigma against persons who use drugs. Next slide, please. So, important results. That's a bit self-aggrandizing. I don't know if the results are important. I mean, I think they're kind of cool, but You may disagree. The whole idea is that legal mapping can help us identify where stigma lives in law. Maybe this is a platform for, there are movements for sort of health in all policies. Maybe there are justifications for rule makers and policymakers to think about what it would look like to pay attention to where stigma might live in the laws and policies they're implementing. Because we focus on vertical mapping, this isn't just meant for legislatures. This can be agencies, and this can even go to counties and municipalities. There is I won't have time to talk about it today, but there's a lot of very interesting anti-stigma work that's happening on the municipal level. The city of Philadelphia, I know, has done quite a lot of work on that with relation to addiction, stigma, and substance use. In particular, the city of Denver, where I live, has done quite a bit on this as well. There are some important limitations methodologically, right? Measuring law and stigma is difficult. There are challenges of construct validity, like how do we separate social disapproval from stigma? We use laws to signal social disapproval of all sorts of conduct that we think is harmful to ourselves and to sort of a just and flourishing society. We probably want to hang on to at least some of those kinds of things, right? So how do we separate laws that express social disapproval from laws that actually stigmatize? In addition to which, right, if all we're ever doing is measuring outcomes to analyze whether these laws stigmatize, we're missing something, because ideally we'd like to measure stigma or have a sense of the likelihood that a law is going to stigmatize ex ante before we put it into effect and see what happens. And then that leads to problems of collinearity and circularity, defining laws that stigmatize in terms of outcomes, and then turning around and using the outcomes that we see to define those laws that stigmatize. There is something circular about that, right? And that can be challenging to deal with as well. Next slide, please. So last thing we'll talk about this is to deal with some of these methodological problems. There is a new working group on law and stigma that has convened that I'm overjoyed and privileged to be a part of. It's convened by Valerie Blake, who I think is here. Hi, Valerie, just waving at you, right? And Mark Katzenbuehler as well, who are, of course, leading voices in law and stigma studies, and they've been leading voices for a long time. The working group is thinking about key issues in law and stigma studies, concepts and construct validity, as we talked about, measurement, how do we actually measure it and code stigma as well, and methodological improvements, right? And I like GIFs or GIFs if you prefer, but for me, GIF is peanut butter. So if you're interested, please get in contact with us. I don't mean to put Val and Mark out there. You're welcome to just contact me. We'd love to hear from anybody who wants to connect with us, of course, as we work on these issues. So next slide, please. I think that might be it actually for me. Is that it? Beautiful. Thank you. I really appreciate it.
Thank you, Daniel. That was really outstanding. And I just would point in with particular methodological encomiums at the clear distinction between trying to measure the attributes of the law and then trying to categorize those attributes in a second operation as being stigmatizing. And the great thing about that is, I mean, first of all, is it's going to improve the accuracy of your the primary topic here is the law and the attributes of the law. So if you just focus on measuring that and not characterizing it in the primary measurement, you avoid a lot of errors. But it's also wonderfully transparent, and we can all understand the model, and we can understand and see how you've applied it, and we can agree, disagree, quibble, make suggestions, and that is so. I think that so beautifully promotes the whole field in its effort to study this, and brings such credibility to your application of the model, that it's wonderful work, and we really appreciate you sharing it. And now we turn to Kelly, who's going to take us to a new area, but probably a very similar set of concerns. Kelly, take it away.
Thanks, Scott. Hi, everybody. Thanks for being here today. I am a legal epidemiologist, and my primary area of research is around abortion laws and how they have changed and how those changes are impacting population health. Next slide, please. So I'm not going to go over this for very long because Scott and Daniel both did such a good job, but ultimately stigmatizing language matters a lot. And reproductive health is an area full of stigmatizing language. I'm just, recounting experiences from my own life that there's a lot of shame and secrecy associated with pretty much every step of pregnancy and birth and nursing and parenting and postpartum mental health and miscarriages, infertility, PMADs. Like there's just an endless list of things that we are, we're shamed about publicly and privately within our families and within our social circles, but also in some of the language that's used, not only by the legal system, but by clinicians and by the media as well. So, ultimately the goal of all of this shame and stigma is to kind of have people retreat and suffer quietly so that they don't make anyone else uncomfortable. But the impact of that is that it creates the illusion that there's something wrong inherently with each individual person, and there's something that I did wrong that created whatever this problem is, right? The situation for me. And that deprives people of community. And so I actually have a really long background working in PMAT advocacy and support, trying to work to create community and push back against some of the stigma. And although Scott did mention that there is, a dramatic increase in support for abortion access and abortion rights in this country, we're still seeing changes in the law. We're still seeing restrictions that are being put into place, and a lot of those restrictions are being put in place by the weaponization of stigmatizing language. Next slide. So speaking of that language, this is a list that was put out by the American College of Obstetrics and Gynecologists, specifically responding to this issue. This is on their website, and this is a non-exhaustive list, I would say, because there are things that are not on here that probably should be, of all of the phrases and the words that have been used, not only in the law specifically, but in society generally, in the media, and in political spaces, I would make the argument primarily to sway public opinion. Some of these terms are maybe medically accurate. Some of them are not medically accurate. And we're going to talk a little bit about that, especially around like the heartbeat bill. I've done a lot of work specifically in Texas surrounding the impacts of SB 8. But there's also a lot of other terms that are on here, like maternal fetal separation is a newer one. And to be completely honest, I'm not even 100% sure what it's intended to mean, but I do know that it's intended to imply some kind of disconnect between the fetus embryo and the pregnant individual that could be used to advocate for some of these newer laws that we're seeing proposed in different states. Next slide, please. So when we think about where we find stigmatizing language related to abortion, really it's everywhere. It's in every piece of our society. So in the law specifically, we see it in statutes. We also see it in funding mechanisms when we think about like the Hyde Amendment, and we think about the Mexico City policy. It shows up in briefs, it shows up in court opinions, but also it's everywhere else in our society as well. So it's in politics, it's in public discourse, it's in the media. There's a lot of research specifically on the accuracy of the portrayal of pregnancy and abortion, specifically in TV shows and movies, not just in news, but in what it should be entertainment and how accurate it is. But also in the field that I work in research, we are not to be absolved of responsibility here as epidemiologists, and in public health, we sometimes use stigmatizing language too. And it even happens in clinical spaces. And so the argument here is that we want to learn and do better so that we're not perpetuating the stigma. Next slide. And ultimately, I would make the argument that I think that the recent kind of shifts that we've seen in the law, it is a question of intent, because I think that a lot of this language has been manipulated and it has been used for the purposes of primarily swaying public opinion, because language is really powerful. And the words that we use and the ways that we choose to use them have the ability to shift how that receiver processes information and can become its own form of misinformation. So the most kind of glaring example of this is that when we hear the term fetal heartbeat, it tends to refer to the moment when so it's actually embryonic cardiac electrical activity. The heart is not fully formed yet. And that usually happens around 6 weeks. The fetus is not a technical term that's used in medicine until after 8 weeks. So this term, fetal heartbeat, is not even correct. It's not even accurate. But it's more impactful. It makes people feel like this is more of a baby, right? So they get more emotionally attached to the idea of any kind of termination happening beyond that point. So, excuse me. So I would make the argument that I think that the use of this term, not only is it scientifically inaccurate, but it is being done with intention to shape how people approach this issue and how they feel about it. Next slide. So this is an example specifically. So this is the text of Texas's SB 8, number 8. This is their heartbeat laws, what they actually titled it. And they do define fetal heartbeat as the moment when you can detect the embryonic contractions of the electrical activity. It's 6 weeks. It's not 8 weeks. And so the use of the word fetus here is problematic, but it still was passed into law. It was still signed into law, and it is still on the books. Next slide. And I think it's really important to also to conceptualize the difference between medically inaccurate and stigmatizing, because they are not the same things exactly, but they are frequently overlapping. I was actually trying to think of an example that I could come up with that was medically inaccurate but not stigmatizing, and I couldn't think of one. So if anyone has one, let me know. We can talk about it later. But really, a lot of the medically inaccurate information that is used and shared in society is also done with the intention of also stigmatizing and othering, right? So we want to see people in a different way. One of the examples that I would use for this as being able to differentiate these two concepts is even clinicians often use the term elective abortion. And when you really start to unpack what that means, what is the consequence of an elective versus a non-elective abortion, right? So there's almost like an element of fault or responsibility that's being ascribed to the person who's having an elective abortion versus somebody who is in a situation of medical necessity. And so a lot of people who work in the abortion space would advocate for just the use of abortion, period, and not specify what type of abortion it is. Next slide. I also think it's really important to think about how we describe people, because when we're talking about people who are capable of pregnancy, we know that that is not just people who would describe themselves as mothers, because certainly a lot of them, especially if they're seeking abortion, may not even define themselves that way or ever want to. In a slightly bigger circle would be the people who do not want to categorize themselves as women, right? Because we know that not everyone who can become pregnant would classify themselves as a woman. So when we're thinking about the way that we use these terms, even in research and clinical spaces, we need to be a little bit more intentional about how we choose to speak. Next slide. And really this recent shift in the use of this language isn't limited to abortion. We're starting to see more of this language kind of being manipulated to describe birth control methods that are now being targeted for attack by anti-abortion advocates. And they're using terms like abortifacients to describe IUDs and emergency contraception, even though that's not scientifically or medically accurate. And the fetal personhood bills are also kind of attempting to do that as well. And so again, my argument would be that these are not accidental uses of language, that they're really intentional and being done to shift public opinion and to shift the opinion of the people who have the ability to vote on these things in the legislatures. Next slide. So when we think about the potential outcomes that could be related to stigmatizing language related to abortion, there's a long list. And again, this is not intended to be an exhaustive list. I personally have done research on probably half of these topics. But one thing that I'm actually really excited about is that we have data in Colorado now from a survey that is actually, for the first time that I'm aware of, doing a large scale statewide survey looking at medical gaslighting and bias in treatment by providers. And I'm curious to see if there's any way to use that data in a way that we could study these types of relationships with stigmatizing language. But the other outcomes, specifically, like if think about like walk through the process of like how these laws get passed, right? So if you're using some of this language to restrict abortion beyond the fetal heartbeat, that's not a fetal heartbeat, it becomes very difficult for anyone to obtain an abortion before 6 weeks, because especially if there's a waiting period, it can take time, right? So we're seeing an increase in travel, less so now because of the availability of medication abortion, but that's one thing that I've studied, is how much this has impacted people's necessity of traveling out of state. And there's just kind of an endless list of things that we can study related to this. Next slide, please. And briefly, I just want to go over some of the publicly available secondary data sources that might be useful if you're interested in doing work like this. So there are databases that categorize state law, like Law Atlas. I am working on, for my fellowship with Temple, working on developing a data set for K through 12 sex ed that will incorporate elements of stigma with it as well. So be on the lookout for that someday. But there's also all kinds of data that you can use to find outcomes that you can maybe use to connect with the stigmatizing language that's available in the law. One thing I will mention is that I have done travel data studies, and that data is now probably impossible to get access to. It was difficult to find when I was initially doing my research in 2021, but it's probably even more so now. And ideally, I really want to actually push the need to disaggregate data whenever possible. So if you are using one of these large publicly available data sets, make sure you're doing that to see if there is detectable differences in how this is impacting different populations. Next slide. And I just want to close by saying that some of my work has made me come to the realization that these exposures are not isolated, right? Like people are most likely being impacted by the consequences of multiple laws that may be overlapping and may be affecting them in different ways. And the current methods that we have aren't always the best to study those laws in combination, especially if they're highly correlated with one another. So I have actually been working on developing an exposure metric to combine those differences in state laws because of the correlation issue. So if anybody's interested in talking about that, I would love to talk about that more. And I think that is my last slide, except for questions and comments. Thanks.
Thank you, Kelly. I mean, it's so striking the degree to which stigmatization is part of the plan for people who want to suppress abortion, and is distinct from other kinds of legislative tools that can be used to simply restrict behavior without identifying defects in the identity of people who engage in it. So now it is time for questions from the attendees. We have a Q&A pane, which now has no open questions. So
we don't have any questions at this point yet, Scott. So if you had a few for the panelists, you can go ahead.
Well, one thing well, first I'd like to hear about, Kelly, whether you've been working with the group that Dan mentioned, and generally sort of where you both see the next steps in the research.
I haven't yet, but it's on my list of things to do because Daniel is really good at convincing me to do things. But yeah, I mean, I am very interested. I do a lot of Texas specific research because, as he mentioned with California, Texas is also a big state. So we can generally get some of this outcome data populated better in Texas just by virtue of it being a highly populated state. So it's also a good place to study some of the nuances in stigma as well. So potentially, yeah, working on something in that field.
Daniel?
Oh yeah, no. Opportunities, I think, Dr. B. I like to try to find opportunities for us to work together. So yeah, no, I think the Law and Stigma Working Group is pretty recent. It only convened in July 2025, so we're not even a year in. Does that make sense? So a lot of it is still we're working on organizing. We have several different writing groups is what's happening right now. So we're working on several different manuscripts on concept and measurement. So I think reaching out to more interested scholars, we know that the people who are in the working group is not the totality of law and stigma scholars. In fact, that's actually part of the point of the working group, is to try to sort of help people understand that it's big enough almost to be a subfield, if that makes sense. And it probably, like, it would help to treat it as such. So working with scholars like Dr. DeBee and others, I think is high on our list. And we welcome anyone who's in the audience and listening who wants to connect with us as well. We'd love that.
Well, there is some interest in the audience in connecting with you guys, and I'd suggest that they contact you directly to follow up on those conversations. I'm given where I start with Goffman, and with the importance of understanding that stigma in its ultimate form, in its purest form, is dependent for a lot of its effects on the acceptance of the people who have the trait of the idea that the identity is spoiled, or at least of the social reality, a sense that this is, whether I feel bad being gay or having had an abortion or not, I know that really it's just real, that people will disapprove of me, that think I'm terrible. Versus something that we are also very familiar with, which is sort of social moral contest and moral crusades. So we have people who are pro-life and we have people who are pro-choice, and they are fighting a battle which may have little to do with their own personal feelings or experiences of or of anything that would remotely be like stigma, but it's much more about beliefs in various kinds of principles or a set of facts. And the reason that distinction occurs to me to talk about is that the way we proceed to help people fight stigma or to break down stigma that we ourselves are experiencing are very different from the way that we might proceed to fight a battle over social meaning, or essentially a policy battle over what things should be allowed or not. They obviously intersect, but if you think of the fight of abortion rights being about whether you can get an abortion or not under your state's law, that has a different valence, you might say, than a fight over whether abortion is stigmatized. Another important relationship there is that I would say, I mean, my view, and I'm interested in your views, but my view would be that in the most successful campaigns against stigma that we've witnessed in our lifetime, the driving force has been the rejection of the stigma and the sort of organization and movement activities of people who carried the trait, and not some kindness done by lawmakers. Lawmakers recognizing that stigma was a problem and trying to take action against its exercise of stigmatizing behavior came later. So how do we sort of think about the role of law in this world in which there's a dimension of social mobilization, there's a dimension of actual policy struggle that may not be related to stigma, and a world in which law is probably playing both sides at any given moment, both being used to fight stigma and being used to try and promote stigma?
I will say, I don't have forever to talk, and I could talk forever, but the law is being used to fight stigma specific to abortion in many states. Like we have states like Colorado and California that have enacted shield laws, not only to protect providers, but to protect the privacy of patients and data and all of those other things too. So it's difficult because we're seeing in states, especially in states where this is maybe more of a contested issue, where we're seeing some ballot measures that are being put up to vote, and sometimes even competing measures within the same state. And so there's different legal mechanisms that are being used, and it's not just court challenges to whatever the legislatures are implementing, because usually the legislatures are implementing these restrictions in conflict with what most people in the state want, because most people in the United States are supportive of abortion rights. So it's hard to say, because we are kind of at an interesting time in our political environment, and I wish I had a crystal ball and could tell you how this is gonna play out, but I just don't.
Yeah, and I think, Scott, your point, I mean, I've had some conversations with colleagues about this. Law, especially in these spaces, tends to be more conservative and reactionary, conservative little c, not conservative necessarily big C, right? But when we're thinking about true anti-stigma or anti-discrimination work in particular, it's usually, as you were saying, Scott, sort of the social movements, the change is coming first in the norms and the laws and following it, not the other way around. I mean, there are isolated counterexamples, but it's exactly as you described on the whole, certainly in the US in particular, and in the 20th and 21st century. So it's a good question. And I think there's room for people to be more or less sort of bearish or bullish on the capacity of law to drive these changes where there isn't where the social norms yet aren't supporting it as well. I mean, I think that's accurate. And then I think the other interesting thing about it is it opens up space to think about potentially a more capacious model of how law could be used to support those movements, right? Like maybe the idea of remediating stigma and law, and I think this is actually quite interesting and exciting, right? As I was sort of thinking about what you're saying, Scott, is, maybe that needs to go beyond sort of, removing discriminatory provisions. Like that can be part of it, but maybe laws need to be used to support movements and communities who are, as you say, sort of mobilizing the anti-stigma work in particular. Like that's where the work is originating. And I love the idea, one of my sort of main lessons from our colleague Lindsay Wiley in particular is that public health law is not just about restricting people from doing things. Does that make sense? Like that's a very crabbed model of what public health law can do and be. We have to continue to think about the use of public health law as social supports and as supporting people in whether it's making changes or doing things that they need to do. So to me, that's what I would say is it's absolutely right what you're saying, Scott. I think, some people might be a bit more skeptical about whether law can really push changes or merely react to them in these spaces. And I think that's fair. But then we might think about how we can harness laws to support the anti-stigma work within communities themselves, right? Basically, like if that's where it's originating, then that's fine. Like let's do that work and figure out how to harness laws and policies to help those groups and people do the work that they're doing.
That's I think getting us to a nice end here. Um, I really love to see the group that you're working with try and answer those questions and to develop that further. And I think that's why the kind of advances that are being made in understanding what stigma is and how it relates to law are so important, because a lot of this is kind of nuanced. So the whole area of supportive law is an important one. So we know in the HIV era, there was the attempt to pass both non-discriminate or enact non-discrimination law to enable people to be out and open and to in that sense fight the stigma and to organize. There are also sort of some paradoxes. I mean, the whole driver, the behavioral, the characteristic behavior of the stigmatized person is to conceal the stigma. So that makes a kind of interesting relationship with privacy law and with the protection of privacy, because potentially one of the messages that a strong emphasis on privacy protections sends is you better keep this private. It sort of favors or promotes secrecy, which is for many people actually a harmful behavior. I mean, it's very complicated, and I think that's why there's an element not just of what laws to consider, but actually to study whether laws have the effects that we expect. Do people rely on the protections of anti-discrimination law to mobilize and to be more out? Or in some sense, is their mobilization in part a response to the fact that they've given up on law to protect them? And really, we have to look for other ways that law might be supportive. Likewise with privacy, does privacy protection help people manage stigma away from acceptance of the stigma, or does it actually promote the behavior of hiding that we know is associated with harmful stigma? So there's no end to the questions we can ask about what law does if, as you two have really helped us to today, we can actually see the law that's in play and start to think, about what those laws are and what they're doing, and to frame a research agenda in that way. So I want to thank everybody for attending. Pass the word on to your friends. It was an interesting hour. It'll be available for future use. And thank you to our speakers for these really edifying comments and important research. And thank you to Bethany and Alex and the team for organizing this webinar. And with that, I can close the luncheon and wish you a good day.